Hello, my name is Michael Luckman, one of the partners responsible for ThinkHouse at Rag & Co. I will be speaking to Andrew Litchfield, one of our partners in our commercial litigation team, specialising in regulatory work. He'll be telling us how we might survive a raid from a regulator. Andrew, there seems to be a lot of regulatory offences. How likely is a raid?
The truth is, we don't know. The whole idea of a raid is that it catches a potential suspect out, and they don't know that it's going to happen, so they don't get time to prepare for it. You can predict that an investigation is going to start if, for example, it follows a serious accident or a pollution event. But if it's some kind of financial or fraud type issue, then there's no way of predicting when it's going to happen, and you just need to be ready every time.
What are the different types of liability?
Regulatory offences are, in the main, created by statute, but they set up two different types of offence. The first is an offence which requires the investigator to prove some kind of deliberate or intent on behalf of the suspect. Relatively rare in regulatory offences. By far the majority are what's called strict liability offences, where there's no need for the regulator to demonstrate or to prove that there was any kind of intent at all. That the fact that an incident has happened or an event has occurred is usually enough to allow the investigator to prove the offence.
Are there any statutory defences?
There are, as a result of the strict liability nature of the offences. Often the statute contains a due diligence defence, whereby the company is given a defence if it can demonstrate that it exercised all due diligence to avoid committing it in the first place. The problem with due diligence defences, though, is that if the event has occurred, it's quite easy for the investigator to argue that the defendant hasn't exercised all due diligence, because if they had, the offence or the incident wouldn't have happened. Another common statutory defence is where the statute sets up a defence if the defendant can say that they behaved with reasonable practicability. They demonstrated reasonable steps that had been taken to avoid commissioning the offence, and that gives you a little bit more scope for arguing that everything reasonable had been done.
What are the first things someone should do when facing a raid or regulatory investigation?
Ask them who they are, under what powers are they there, and what suspected offences are they investigating. And then show them into a room and start the process of dialogue with them to understand exactly where they're coming from.
And what should they absolutely avoid doing?
In those first critical early hours when an investigation starts, it's extremely unusual for anybody to know all the circumstances of what's happened. And there's a great temptation to try to explain things and to give opinion and even to admit liability when there just isn't the knowledge at that point. So the thing to avoid is to make too many early admissions of liability and to speculate as to what's happened.
If an organisation is under investigation, what is the regulator looking for?
The regulator will have a clear idea of the behaviour and the criminal activity which they suspect may have happened, and they will have a clear idea of the component parts of the offence that they would need to prove beyond reasonable doubt. So initially they're looking to establish the facts, they're looking to establish what happened, and then as the investigation develops they will apply those facts to the component parts of the offence to see if it's been committed.
And what powers does the regulator have?
Wide-ranging powers. As you would expect, they have the ability to come into your premises at a reasonable time. They have and at an unreasonable time if they get a warrant from the court. They have the ability to seize documents, sometimes in many cases to require witnesses to give them witness statements, to require that evidence is left untouched, in some cases to take samples and to test equipment. Wide-ranging powers, everything that they might need in order to gather the evidence together.
How should in-house lawyers advise and support witnesses?
The first thing to do is to understand exactly what type of interview that the investigator is carrying out. And there are three main types. The first is where the witness is asked simply to describe the circumstances of what they saw and what they know. The second is a slightly more serious interview where the investigator is using the powers that they have under the statute to force a witness to give a statement. And the third most serious type of interview is where the interviewee is a suspect in the investigation and they are interviewed under caution. And it's a stressful experience going through any of these interviews, and it's important that the interviewee understands what type of interview it is, the consequences which arise from that interview, and the process which they're going to go through. And those are the practical things which in-house counsel can do to help.
And what about documents? What should be done about document management and generation?
The first thing to do, I think, is to understand that there's a clear line in the sand, if you like, between the documents which existed before the raid began, so evidence which was generated either during the alleged criminal activity but before the raid began, and there's very little that can be done about that. It can't be protected in any way, and the investigators will have the power to obtain it. So I think all that can be done there is to stop its destruction, either in a routine way or deliberately, and then understand what it is, find it first, understand the consequences of it so you can explain the context of it back to the investigator. After the raid has begun, there are practical things that can be done to stop damaging documents being generated, and if it's necessary to generate those documents, to do so in a way where they're privileged from production in the criminal investigation. And it's really important that as well that the content of anything produced post the beginning of the raid or the investigation is controlled as well to stop damaging admissions being made.
Are there other issues to consider?
Yeah, all sorts of things actually which can crop up. It's important to think at an early stage about PR, that the investigation and the raid will be known about internally, so it's important to communicate properly to staff so that they understand what's going on. It may be necessary to make an announcement to the market or to find out from the investigator themselves whether they intend to issue a press release about the investigation and then react accordingly. There could be issues of insurance notification that need to be thought about. There could be human resources input needed. For example, if individuals are under suspicion themselves for having committed criminal offences, or if they're traumatised by what they've seen or personally involved in some way. And then finally, I think it may be necessary to get some expertise involved from an early stage to advise the internal investigation about what is going on and what might happen, whether that's IT related or engineering or any kind of expertise that would assist the company in finding out what happened.
Andrew, thank you. That was very clear.